So we've been on this for a couple of weeks now, right? Disposition without trial is the set of mechanisms we have in the rules of civil procedure by which a case can be ended early, disposed of, and completely resolved, generally through adjudication, but without the necessity of going all the way down that long, expensive road to the civil trial. And last week, and I think on the Thursday before, we looked at several of these techniques, striking pleadings without leaving to amend, summary judgment, that was the big kind of beastly one, determination of issues with it before trial, that was last time based on the Arar case, and then discontinuance and withdrawal. So before we get into some of the other ones, we'll take a look at what people did with these participation questions. Which of the following is a difference between striking out your opponent's pleading without leave to amend and winning a summary judgment motion? So, this is not true of either, right? We don't basically do anything without written materials in our civil procedure system. There's nothing you can get a judge to do just by showing up and asking for it. Everything has to be in writing, and that's sort of how we ensure that that the other side knows what you're after, and the judge can think about it before you actually show up and ask for it. So that's not true of either. This is true of both of these things because this is the definition of disposition without trial. You can end the case completely subject to appeal. Both of these things are also available before the close of pleadings. If you are the defendant and you get a truly outrageous, groundless statement of claim, which seems to be designed exclusively to scandalize your client, or is substantively inadequate in the sense of not containing any claims which could give rise to legal remedies, even if proven, then you as a defendant can move to strike out that statement of claim before you have, or instead of issuing a statement of defense. And the same is true of summary judgment. So this is the one I was looking for, and about half of the people got it. Requires substantive evidence about the issues in dispute, so that's summary judgment. Summary judgment, it's the most trial-like of all of our disposition without trial techniques insofar as it's always substantive and based on the evidence. Sometimes that evidence will come in through affidavits in a documentary form only, but as we saw, Rule 20 is also very flexible, and in the proper case will give the court access to very trial-like forms of evidence, right? Oral evidence, hearing witnesses, and things like that. So summary judgment is evidence-based. This is not, right? Striking out your opponent's pleading, that's a focus simply on deficiencies within the pleading, which would doom the case, doom that pleading, regardless of what the evidence might turn out to show. Okay, so here's a question. I was trying to trick people and I did not manage to trick you. What is the latest point at which a plaintiff can discontinue all or part of an action against a defendant? So this is going back to our material on discontinuance and withdrawal from last time, Rule 23. And Rule 23 tells us that a plaintiff can discontinue. So this is where you want to drop the case, right? You're in over your head. It was a mistake to even start it. You want out. And you can do that unilaterally before the end of pleadings, right? Without getting anyone's permission or any court's approval. The question was actually asking about not the latest point at which you can discontinue unilaterally, but rather the latest point at which you can discontinue. And most people got the right answer, which is that before judgment is given at trial. Because this is what happens whenever a case settles. And when a case settles, the plaintiff will discontinue their action against the defendant in exchange for receiving some type of concession from the defendant. And we know you can settle at any point up to when judgment is given. In our Kansas case, 311 versus Scottsdale Insurance, we saw that those people went through a whole trial and then settled before the judge and jury had a chance to adjudicate it. So that's the correct answer. In what circumstances can a judge grant summary judgment to a moving party? So most people got this. No genuine issue requiring a trial. This is section 20, our summary judgment rule. And disposition of the motion, 20.04. 20.04 sub 2 sub A, no genuine issue requiring a trial. It used to be no genuine issue for trial. This is the kind of, so they changed from this. That was the old one. This is the new one. It's a sort of minor wording change that they like to make a big deal over. But whether it changed things on the ground is unclear. But the goal of the change was to expand the scope for summary judgment, right? Previously, the idea was judges would refuse summary judgment if there was any issue that you could have a trial about. Now, the drafters of the rules don't want judges to refuse summary judgment unless that genuine issue requires a trial. Because the whole thrust of Horiniak versus Malden and of the reforms to Rule 20 have been to, in the name of proportionality, make this summary judgment business more robust and more capable of resolving more cases. Okay, so here we've got a lawsuit. Jack sues Jill. Stating the claim is concise and measured. It's not scandalous or anything like that. But it's making a claim which the law, to say the least, does not really recognize, right? This is not something that the law grants remedy for. So there's a couple of good answers here, right? So 21.01 sub 1b, look at that right here. Move before a judge to strike at a pleading on the ground that discloses no reasonable cause of action or defense. So that's a correct answer. 25.10 is not in your readings. So, sorry, it is in your readings, but it's not relevant. It's the one about particulars from before, so that's not on. This could also potentially fly. 25.11, let's look at that. Scandalous, frivolous, or vexatious. So this might fly as well, right? Frivolous would be where it is here. And just as with Gomeshi, often you will plead both parts of this, right? Both 21.01 sub 1b and 25.11b, and this is not correct. Okay, so these questions here, I don't really know what this means. Yeah, that's not very helpful. Let's go through it this way. So here we're just trying to get a sense of how all these things, these different items in our disposition without trial toolbox can be used. So pure legal analysis, that's determining the question of law. That was our RAR case where you can get at an answer that will dispose of the whole case without having to look at the facts. If you can do that, then that's a great opportunity to resolve our dispute without having to spend much money. May involve oral evidence. That would be summary judgment. Can be used to attack scandalous or purely defamatory pleadings. And that would be striking pleadings without leave to amend. And then it's unnecessary before the close of pleadings. Motion for interlocutory injunction. I don't know why that says that's unnecessary. Sometimes you might bring a motion for interlocutory injunction. Let's just leave that one unselected. I don't think this, I'm going to look at this question because there are cases in which you would bring a motion for an interlocutory injunction. People remember what this is, right? This is where you need some kind of remedy urgently before you can get all the way down to trial. So we didn't really talk about when you can get these, But yeah, let's just leave that one blank, and we'll change that question. So don't worry about that. Okay, so here's another one. Motion for substitutes. This is again matching things together. This, can anyone remind us what this is? The motion for substituted service. We're talking here about typically documents that would, under the rules, have to be served personally. So when you're initiating a lawsuit against someone, you have to do that kind of gold standard, highly demanding process of showing up at their house or their business and giving it to them personally. Motion for substitute service is when you can't do that for some reason, you're getting the court's permission to do something else. So that is not a form of disposition without trial. That's a procedural motion. Same is true of this, motion to compel disclosure of documents. The other side is not being forthcoming with documents that you say are relevant, that's great, you can bring your motion, but that's not going to end the case. At best, what you're going to get out of that is an order that the documents be produced. Strike pleading without leave to amend. Okay, so let's do this one first. Summary judgment is E. We know that already. That's one of our evidence-based substantive form of disposition without trial. And then we have strike pleading without leave to amend would be B, right? Because you can knock out your opponent's whole case based on problems in the statement of claim or defense without having to get into the evidence. And determine question of law, so that's C as well. So hopefully that makes some sense, with the exception of this, which I will have to fix. But what did I do? Oh, A, right, A, yeah, sorry. There we go. All right, am I back on track? Let me know if I'm off track. Okay, good, thanks. Appreciate it. So we come now to question 7. So here we've got someone who is floundering, right? You're on for this poor Steve's sub shop, and you brought this case, but it's going terribly. Nothing is lining up. You know, a lot of lousy and unethical lawyers in a case like this, if they have a client who's willing to keep on paying the fees, are going to keep on proceeding right up to the point of where they lose and their client has to pay a huge cost for the other side. If you're a good ethical lawyer, you don't do that. You want to get out of this as quickly as possible. And most people got what we're looking for here, right? Discontinuance and withdrawal. That's the only one that you can use if you are trying to get out of a case that you yourself started. Okay, so let's go on and talk about some more of our disposition without trial techniques. We got through this last time, right? We got discontinuance and withdrawal, and we come now to default judgment. So this we've had some experience with before. We case when we're talking about pleadings, which was all about the Martosh and Horton case, where we had a claim that was brought against someone who was evading service, and then the plaintiff had to go to court and get permission to serve it in a different way, and eventually got default judgment against them. But we need to talk about Rule 19 in more detail now, right? Because this is also a not uncommon form of disposition without trial. So Rule 19 was in your readings, and if you're in default, that sounds bad, right? And it is bad, but it doesn't actually mean what your clients will often expect it to mean. Right? Clients, if your client is the plaintiff and the defendant doesn't do anything, your client will often think that that means they win automatically, right? And that the plaintiff can move directly to the enforcement stage of the proceeding, actually get that money or change the world in the way that they want it to change. That's not actually the case, right? So, oh, that was the last one. Rule 19 tells us that if you're found in default, you don't lose automatically. You end up in this sort of purgatory type zone, right? Where you're found in default, and then certain specific things happen, right? Under Rule 19.02. First of all, the defendant is deemed to admit the truth of all allegations of fact made in the statement of claim. So the defendant loses their ability to deny the specific factual allegations which the plaintiff has made. And secondly, that the defendant can't do anything. They can't deliver a statement of defense or take any other step in the action other than a motion to set aside the noting of default. So the defendant is kind of in this purgatory zone, and the only thing they can do is move to have it set aside. And so basically, you can think of it as the defendant gets a second chance. Once they're in default, they can show why they were in default and have it set aside. And if that default is set aside, then we're back into the normal process of the conventional civil action. So Rule 19.08 sub 2 is the one we looked at before, right? So that was the one that was under the pleadings section of your rules, where it gives you the test for setting aside a default judgment, where you can, and we looked at the test when we went through the Martosh and Horton case. So it's kind of a tough pill for plaintiffs to swallow, as I say, right? Most of them probably think, if the other side doesn't even show up, then that should be the end of it. I should just get what I wanted. I paid you all this money to draft a statement of claim to get. So, like the Nationals and the Astros are playing in the World Series tonight. If the Nationals just don't show up for the game, then the Astros win, right? We don't engage in any scrutiny of how their starting pitcher would have been, or what the injury roster is like. We just say that the Astros win. That's kind of what clients expect when it comes to default judgment, but that's not the case. And it all comes back to liberality. We've said before that we have this sort of liberal approach to a lot of these rules, and this is another example of that. That even if you don't do anything, you're not permanently out of the. Okay, so what happens then if you don't get to automatically go to enforcement? What exactly can you do if you are the plaintiff and the defendant doesn't do anything? So you note them in default, and then how do you go about how do you actually do that? Well, there's an easy way and a hard way to note a defendant in default once I've run out of time to deliver their statement of defense. The easy way is under Rule 19.04 sub 1, where the registrar signs judgment against the defendant. So a registrar is basically kind of a senior court clerk or official. And if you qualify for this sort of easy path under Rule 19.04, that means you just go to court and you prove that they're in default, and then the order will be signed. But you can only do that in a very narrow set of cases, right? Basically, these cases where they're the simplest type of civil litigation, where the amount that's at stake or the remedy which is being sought is not subject to any sort of debate or legal dispute, where there's specific contract saying that amount of money is due, or there's a piece of land which is subject to a very clear mortgage. In those cases, we make it easy for the plaintiff to just go ahead and get default judgment without having to go before a court again. But if, like the majority of plaintiffs, you're not fortunate enough to have a claim which fits within this narrow set of possible proceedings, then you have to turn to Rule 19.05 and bring a motion for judgment. So this is a tougher road to hoe, right? So you need to have evidence. You need to evidence given by affidavit if it's a claim for unliquidated damages. So unliquidated damages means damages which have not been set. So liquidated would be like, it's a debt. It's a specific debt. So it's liquidated in the sense it's absolutely clear how much is at stake. Unliquidated would be where there's some uncertainty about how much the amount actually is of the damages. And you have to bring evidence, and the judge can say yes, they can say no, or they can say we have to actually go to trial and have oral evidence. So again, bear in mind this is all for cases where the defendant has done nothing, where the defendant is in default. So even when the defendant does nothing, we are still scrutinizing what the plaintiffs claim, and we're not granting it to them automatically. And Nikore versus Jarmain is the case that shows how this works. Okay, so Dr. Nikore, let's just see a rule. Right, Dr. Nikore. So she buys this. She decides to build this beautiful house in Mississauga, and she buys the land from a corporation called Jarmain Investment, which holds the other part of the land. Right. So Jarmain had a big chunk of land, and they subdivided it and sold part of it to Nikore while retaining the other part. So they're neighbors. But they're not happy neighbors. Why did Dr. Nikore sue Jarmain Investment? What was the essence of her complaint about her neighbor, who was also the vendor of this land?
Hi. So basically, she was told when she bought the land that nothing encroached on her property, and then she later found out that something did encroach on her property, and so she had to kind of redesign what she had envisioned initially.
Yes, that's right. That's right. Or so she says, right? She becomes convinced that they have encroached onto her land. So an encroachment is where something from your land goes onto your neighbor's land, and that can be on the surface or below the surface, as Dr. Nikore assumed in this case. Okay, so she has to redesign her house, and she's going to sue them to recover damages for breach of contract, misrepresentation, and loss of the enjoyment of her land. So it's a septic tank, right? So this underground apparatus for treating your sewage, which she says sticks from Jarmain's retained portion onto hers. Okay, so what does Jarmain do in response when she brings this claim alleging breach of contract and misrepresentation? So being noted in default is not something that they do. Yeah, they did nothing. They do nothing at all. Okay, so their deadline for passing a statement of defense passes. They're noted in default, and we move to a Rule 19.05 process. Right. So Dr. Nikore is not within the select fortunate group of plaintiffs who can avail themselves of Rule 19.04. She has to use this harder, more complicated route. So we have this is also known as like an undefended trial, where we have just Dr. Nikore's lawyer and the judge in the court, right? Because Jarmain is still not showing up to play ball. So they're in default, which means that Rule 19.02 subsection A applies. Right? They're deemed to admit the truth of all allegations in her statement of claim. So she says, Well, that means this is just about damages, right? I win. The only thing left I have to show to you, Mr. or Mrs. Judge, is exactly how much the value of my damages are as a result of this. The court says, hold your horses. Yes, they're all, yes, your allegations are deemed to be true. However, that doesn't necessarily mean you are entitled to judgment. You have to establish, on a balance of probabilities, your entitlement to any specific order that you might be seeking. And that's for a couple reasons. First of all, 19.02 sub A clearly says that the defendant is deemed to admit the truth of all allegations of fact. And conspicuous in its absence from this sentence are allegations of law. They're not deemed to admit liability or to admit any of the plaintiff's claims about what the law entitles them to. Just the facts are admitted. Secondly, we have Rule 19.06. A plaintiff is not entitled to judgment on a motion for judgment or at trial merely because the facts alleged in the statement of claim are deemed to be admitted unless the facts entitle the plaintiff to judgment, right? And that's a legal question, whether these facts entitle the plaintiff to judgment. So that means they're going to look at the evidence, and the court can say, your damages are not as much as you say they are, but going even further, they can say you lose. You're not going to get anything because we're not convinced on a legal level. Okay, so paragraph 21, we get a review of these factual allegations, right? So deemed admissions. This is the stuff she said in her statement of claim. Basically, Nikore says, you promised me there were no encroachments, and the city inspector came by and sort of implied, like it looked to the city's inspector as if your septic tank was sticking onto my property. If so, that's an encroachment, so I had to tear up my plans, etc. Okay, so that's not the statement of claim, but that's not the only evidence, right? We have this Dr. Barker, Mr. Barker, who comes on the scene, this engineer. And Barker basically convinces the city to let Dr. Nikore put her own septic tank and her own pool in the originally planned location. And Barker comes to the trial, the undefended trial, and testifies. So Barker's testimony is not entirely aligned with the statement of claim. Right? The statement of claim is now evidence because those are all deemed admissions, and that means the statement of claim constitutes evidence, but it's not entirely aligned with the testimony at trial of Robert Barker. There's inconsistencies, and these are laid out at paragraph 36. And by far the most important of these is this one, that there is no encroachment. Right? So Barker testifies that, yes, the city thought there was an encroachment because on part of Dr. Nikore's land, there's this sand of a type which is usually placed on top of a septic tank. So the city assumed, well, that sand is on her land, so there must be a septic tank underneath there. But in fact, that's not the case. That was just some sand. And the real septic tank on Jarmain's land does not encroach onto Nikore's land. Therefore, if you're upset about this sand, then the solution is to move the sand, not to move the house. And moving the sand costs no money at all. So she's not going to get anything, right? She's got her defendant noted in default, but there's no damages because the whole thing was factually incorrect. And the case illustrates why why we have Rule 19.06. because just because the defendant hasn't showed up doesn't necessarily mean that we should be giving orders and ordering damages against the defendant, because it still might be the case that the plaintiff is wrong. So it's an interesting kind of takeaway for legal practice as well, right? Because if you're on for Dr. Nikore, right, and she's upset about this encroachment that she believes exists, so Dr. Nikore comes into your office, and you're a good lawyer, you're an okay lawyer, then you'll draft a great statement of claim, and you'll have it served and filed on Jarmain. You'll carefully keep track of the time, so you know when Jarmain's time is up. You'll make sure to have them noted in default. You'll turn to Rule 19. You'll bring your Rule 19.06 motion, and you'll go through all of this. And then at the end of the day, what does Dr. Nikore have? She has a $10,000 or $20,000 legal bill, and that was completely unnecessary, right? Because she didn't. She never needed to go to court to get what she really wanted, which was to build her house in the way she initially planned. Which is why a great lawyer, by contrast to merely a good one, a great lawyer will talk through with Dr. Nikore, what happened, and ask her, why are you so sure there's an encroachment? Why do you think there's an encroachment? What exactly did the municipal person say? Is it possible that they were mistaken? And probe about whether there's a way to sort of get her what she wants or satisfy her without having to bring this very expensive motion. Okay, so how does the evidence work here? So Rule 19 says that in a motion 19.05 sub 3. Right? The judge may grant judgment, dismiss the action, or order that the action proceed to a trial and that oral evidence be presented. So that's probably exactly what happened here. That somehow the judge's sentence was up because there's no defendant there to argue against this, and the statement of claim is deemed to be admitted. But the judge was of the view that this was necessary, and it's a good thing, right? Because the oral evidence ended up pointing in a different direction. So if the judge orders that oral evidence be presented, then that he'd require a specific sort of evidence to be required, and that would have been Dr. Barker or Robert Barker. So it's not exactly the court investigating. This still is a sort of adversarial party-driven process, but the party, even if the matter is undefended, still has to comply with the court order. Otherwise, they're not going to get anything out of the court. Okay, so I think that's what we need to say about that. So let's move now to this one, right? Gag proceedings, a relatively new part of our civil procedure. And the reason why we have this, it's also known as, probably more commonly known publicly as anti-SLAPP legislation, right? So SLAPP stands for Strategic Lawsuits Against Public Participation. And this is a manifestation of our concern for freedom of expression and for the potential for litigation to constrain freedom of expression and prevent people from engaging in forms of communication which are very much in the public interest. Right? As you know, freedom of expression is a constitutionally protected right in Canada, and our legal system is especially keen to protect it when people are communicating about matters of public interest. People have a very important right to speak up about what corporations in particular and governments are doing, and to bring popular attention to possible misdeeds. And so this section was created because there was a concern that corporations, and in a few cases governments, were using lawsuits to silence their critics and to prevent public discussion of what they were doing. So what tort is it? What tort do you use if you want to hold someone liable for something they said about you, which is causing you damages. Bingo, defamation, right? So these SLAPP lawsuits are very often defamation lawsuits, but not exclusively. They're any type of lawsuit, whether a lawsuit is a SLAPP suit and subject to Section 137, depends not on the nature of the tort, but rather on this test that we're going to see. Okay, so at first blush, it may seem like this is necessary. I'm not sure people have talked about defamation in torts or some other class, but defamation law, like the doctrine of defamation law, incorporates a concern for freedom of expression, right? So if you're sued for defamation, even if you can't prove that what you said is true, you can still, if you can prove that it was fair comment about something that's in the public interest, then you will not be liable for that defamation, right? So this is important, right? So the longest standing, most ancient defense to a defamation suit is that whatever you said is true, and the truth can never be defamatory. But even if you can't prove that, even if it might have been false, if it was talking about something that people are generally interested in, it's a matter of public interest, then you can still defend yourself on that basis if it was fair comment. So that's kind of within defamation law already. So it's a natural question to ask, why do we need this? Defamation law already takes care and thinks about freedom of expression. So what is the problem? Can anyone help us out here? Why do we need to be talking about this in civil procedure and have this special section when the black letter of defamation law doctrine is already attentive to freedom of expression, is already seeks to balance our public interest in freedom of expression against the damage that communications and expression can do to people. If you've expressed yourself about something of public interest, and you know that any corporation, any big corporation offended by what you did, if they ever take you to trial, you'll have a fair comment defense. Why is that not good enough? If you or I or any individual is thinking about, protesting against a big corporation, why is it not comfort enough to know that if we get a defamation trial, we'll be able to defend ourselves on the basis of fair comment? So I think about it from the point of view of like the last offensive thing you saw a corporation did, that maybe it's a fossil fuel company, or the way Facebook treats private data or something like that, and you're thinking about kind of mounting a campaign against this, and maybe doing a protest outside their corporate headquarters and bringing an op-ed piece and spreading the truth. And I'm your lawyer, and I say to you, okay, look, so they might sue you for defamation, but if they do, don't worry, because you'll just go to trial, and you'll mount your fair comment defense, and the judge or jury will adjudicate in your favor. A2J, yeah, so it does have to do with A2J. This is it, right? That even if you're guaranteed to win if you go to trial, you can't afford to go to trial if you're a normal person, right? And the word strategic here, right, means a strategic lawsuit is a lawsuit which the plaintiff does not expect to win, right? They're not counting on having it adjudicated in their favor if it gets to trial. The point is that merely involving someone in civil litigation is a huge threat and a huge deterrent to them to do what they might be legally entitled to do. And this work, strategic lawsuits are most effective when there is a great disparity in resources between the parties on both sides. So, if you mount a public campaign against Facebook and they sue you for defamation, and it goes to trial, and they lose, then you'll get a cost award. So Facebook will have to pay its lawyer and have to pay your costs, but that's nothing to Facebook, right? It's everything to you if you're an average person. So the idea here is that if we want to protect freedom of expression and we want to find the correct balance between people's ability to express themselves about matters of public interest against, the right of corporations not to be defamed, then we can't leave it to trial to get that balance right, because the threat of the lawsuit is so overwhelmingly terrifying to an individual that that letting corporations make that threat is would kind of foreclose the possibility of engaging in free speech against corporations or governments which are much deeper pocketed than you are. Okay, so hopefully that makes sense. So this was a concern which led to the creation of this section in 2016, and it's kind of been a thing in many jurisdictions across North America. So Section 137 here starts by telling us what its purposes are, right? And it's basically all about freedom of expression, to discourage the use of litigation as a means of unduly limiting expressions. That's those strategic lawsuits we're talking about. That, from a corporation's point of view, the fact that you will definitely lose if your suit gets to trial does not foreclose its utility, right? As a strategic approach to silencing people, and that's the fear of legal action. Okay, so this only protects expression, right? But expression defined broadly and sort of in line with our Supreme Court of Canada jurisprudence about freedom of expression. So any communication, verbal or nonverbal, public or private, whether or not it's directed at a person or an entity. And if you're engaging in this expression, well, let me tell you about the case first, because that'll kind of show how the facts work. So the case we're looking at on this is the Fortress versus Rabidoux case. So Fortress is a big real estate developer, right, active across Canada. And one of the things they're into is these syndicated mortgages. Anyone ever invested in a syndicated mortgage? It's kind of like an edgy sort of investment, where you get a whole bunch of people who pool their money, and then that money is basically lent to a developer, and then the mortgage is kind of held by them collectively. So this is something that Fortress promotes. They try to get investors into these syndicated mortgage deals. So on the other side, we have Ben Rabidoux, right, who is a critic of Canadian real estate developers and a critic of Fortress in particular. Right, he thinks that Fortress is misleading people about the syndicated mortgages and kind of effectively fleecing small investors. He thinks that Rathore and Petroza, who are the principals of Fortress, are more or less crooks. Ben Rabidoux shares these views on Twitter. This goes through a couple rounds, right, where he criticizes them on Twitter, and then Fortress, they go after him, they sue him for defamation, he apologizes, and then sort of promises to never pay anything to them again. He promises to pay them $10,000 if he ever says anything about them ever again. Okay, so this deal is in place. Then we move to round three, right, where Rabidoux is back on Twitter. He doesn't mention Fortress by name. He doesn't mention either of their principals by name, but he talks about things going on in the syndicated mortgage industry. He talks about certain developments in Western Canada. And Fortress says, well, he's talking about us. Everybody knows he's talking about us, even though he's not using our name. So he is violating his agreement with us, and he's defaming us. And this, Fortress says, is going to cost us big money, because all of these investors who would be participating in our plans are going to avoid us as a result of his false and defamatory statements. Okay, so Rabidoux now has the benefit of Section 137, and he brings a motion on that basis. Okay, so he says we have the test here, right? So the first part of the test, In the first part of the test, the onus, the defendant has the onus, right? So remember here that these are cases where the defendant is the little guy and the plaintiff is the big corporation, which is suing the little guy for defamation. So the defendant, first of all, bears the onus under section 137.1 sub 1 sub 3 to show that the proceeding arises from an expression made by the person that relates to a matter of public interest. Okay, so for the judge hearing one of these motions, the first question is, has the defendant shown that, there was an expression within the definition of section 2, and then the defendant has to also show that that expression relates to a matter of public interest, and that the proceeding against them arises from that expression made by the person that relates to a matter of public interest. So the court in the Fortress versus Rabidoux case tells us a few interesting things about this this public interest question, right? Was this expression in the public interest? Because, you know, if you just if no one cares, right? If it's just like you know, you're talking about someone and you're just talking to a very small private audience about what that corporation did, then it may not pass this public interest test. But that being said, public interest is fairly broad in the way the court describes it here. They say that it's not about the manner of the expression, and it's not about the motive of the author. Okay, so it's not about the manner or the motive. So it can be very sarcastic, right? You don't have to, if you want to like talk about what corporations are doing in your community, in your country, you don't have to write peer-reviewed, perfectly footnoted essays or op-eds in the newspaper. It's entirely acceptable to use Twitter or to use just casual speech. And you can be sarcastic too, right? So we're not going to say that expression is not in the public interest just because it doesn't meet some sort of high academic standard for expression. Nor are we hung up about the motive of the author, right? So even if Rabidoux is like, you know, he actually hates Fortress because, you know, Fortress's CEO was sleeping with his wife or something, that motive does not disqualify his expression from being in the public interest. So finally, we're not getting into the merits. We're not going to look into whether he's right or wrong about Fortress. None of that matters because we're talking about freedom of expression, and we are very scared of judges being in a position to you know, decide substantively which forms of expression are better than which other ones. Okay, so that's the public interest piece. So if the plaintiff passes this threshold, right, expression about a matter of public interest, and that expression gave rise to the lawsuit against them, then the onus switches back to the plaintiff, which is to say the big guy, right? And the plaintiff can avoid the application of Rule 137 if they can show these three things under Rule 137.1 sub 4, right? So the judge should not dismiss the proceeding if the responding party satisfies that the judge that there are grounds to believe the proceeding has substantial merit, and there are grounds to believe the moving party has no valid defense in the proceeding, right? So here the plaintiff is going to be trying to show that this really is defamation, like the defendant really would not have a fair comment or truth or any other defense if this were to get to trial. And finally, there's a balancing test here, right? That the harm likely to be or have been suffered by the responding party as a result of the moving party's expression is sufficiently serious that the public interest in permitting the proceeding to continue outweighs the public interest in protecting that expression. So this is all about the fact that we've got a conflict between two important public policies here, right? On the one hand, defamation is a thing. We have a tort called defamation. No, you are not allowed to say and write whatever you want about other people if it's wrong and it damages their financial interests. You can't do that. And when we're talking about Rule Section 137, we're talking about foreclosing the right of a party to bring a tort to which they may be entitled. So we don't want to do that lightly. And we're balancing against that the fact that these lawsuits can be strategic, and we definitely don't want strategic lawsuits to prevent freedom of expression. So that's why we have this, right? The plaintiff has a chance here to show that the harm that they're suffering as a result of this defamation is great enough to justify to justify the lawsuit, right, and to justify turning down the moving party defendant's effort to use Section 137. So it's a bit of a balancing test. Okay, so in this case, the Rabidoux wins. Right, and he wins firstly because Fortress fails to lead evidence of the actual harm they've suffered. So the actual harm would be like, so evidence of that would be, we were signing up investors hand over fist up until December 23rd. At that point, our rate of new investors really fell off, and that was the very same day when Rabidoux started tweeting again. So that would be kind of the kind of evidence they could have brought. They didn't bring it. And also the fact that they had this gag, this sort of deal where they wanted to make him pay $10,000 if he ever talked about them again, was evidence that they were in fact trying to suppress his freedom of expression. So he's granted his Section 137 motion, and the lawsuit against him is disposed of without trial. Okay, so it's an important form of disposition without trial to know about. It's available early, right? You can bring it instead of a statement of defense if you are a defendant and you fit within the facts. All right, so now we're on to these two down here, right? So dismissal for delay and the Limitations Act. And what these have in common is that they are both responses to the time issue, right? To how long it can take for civil litigation to grind its wheels to a conclusion, and efforts to prevent plaintiffs in particular from dragging the puck for too long. So we already know. Does anyone remember how long we've talked about how long civil litigation takes? I think I mentioned a couple times the average time it takes for a pleading to get to trial. Yeah, 1 to 3 years, average 2 years. Yeah, so anywhere in there, which is a long bloody time, right? And if you think what you were up to 2 years ago, in your innocent pre-law school days, like if something had happened back then that was a big problem for you, and like if you were still looking for a resolution and you had to be like thinking about it and working about that problem, whatever it was, since back then. Okay, so first we have Rule 24, right, which is only available to defendants. And it says that a defendant who is not in default under these rules or may move to have an action dismissed for delay where the plaintiff has failed to serve the statement of claim within the prescribed time, to have noted in default defendants who failed to deliver statements of defense. So this is actually an interesting one to bear in mind. You may want to put a reference to this back in your notes on default as well, right? That if you have a defendant who is in default, then the plaintiff has to note them in default within 30 days when the default actually happens. Otherwise, it's sort of the plaintiff who's delaying because they haven't moved that along. So that's an example of why, if you find yourself in a civil litigation practice, it's very important to have some kind of system that that keeps track of deadlines. Right? We call it a tickler system often, where it like reminds you, at a specific time, and that has to be set up for each particular case based on when the deadlines are. Anyways, if the plaintiff has kept their nose clean, they have not, the defendant has not not in default, and so on, and the plaintiff has blown through one of these timelines, then you can bring this motion to have their action dismissed for delay. So the thing about these deadlines, right? The deadlines are not as etched in stone as you might think. And merely blowing through a deadline, if you're the plaintiff, is not in of itself sufficient to have your action dismissed for delay, right? Dismissal is a draconian remedy because it's often, if there's delay, it's often the fault of the plaintiff's lawyer as opposed to the plaintiff themselves. And it basically is, if an action is dismissed for delay, that's the system saying, we're giving up on ever getting to the bottom of this, right? We're giving up on having a substantive adjudication based on who did or didn't do something wrong. And that's not something the system wants to grant lightly. So Armstrong versus McCall tells us what our test is for granting dismissal for delay. Okay, so poor Mr. Armstrong fell off a ladder and he fractured his heel on August 20th of 1997. So he went to the hospital and he was treated for this fracture. His heel became infected, and he was treated for this infection to his heel over the course of the next 2 weeks. It never quite healed the way he wanted it to. So Mr. Armstrong says that the treatment of this heel that we received in the hospital was negligent and deficient, and he goes ahead and sues everyone involved. He sues the doctors, he sues the hospital, and he sues the nurses. Medical malpractice is the name of this tort. Okay, so he does all that in August of 1998, so right about a year after the actual injury, right? Often you have to let these things play out for a while. Maybe it would have healed by itself, but it didn't. So he brings this statement of claim a year after the injury. 1999 is a busy year for the case, right? We have the statement of defense is issued in January. And then we have affidavits of documents are issued in April and June. Examinations for discovery began in August. Things seem to be marching along into the case's second millennium. Unfortunately, in 2000, basically nothing happens all year in this case. 2001, however, we do get something happening. We get some more examination for discovery, right? You already know that under Rule 30, Rule 31, you're allowed to examine adverse parties, each adverse party once. So in this case, we've got a bunch of adverse parties. We've got doctors, hospital, nurses on the defendant's side. Each one of those is going to be both trying to show that there is no valid claim, or to the extent that there is a valid claim and he suffered some damages, it's in fact other defendants who should have to pick up the ball on that. So lots of different examinations for discovery. Okay, so these continue into 2001. 2002, we have further examinations for discovery scheduled, but the plaintiff's lawyer screws up the date. Doesn't show up, so mistakes happen. We'll have to keep on going and have some more examinations for discovery. In 2003, okay, so this is 4.5 years after the statement of claim was first issued. The defendants bring their first motion to dismiss for delay. So their first motion under Rule 24, saying the plaintiff's blown through too many deadlines, it's taking long we want dismissed for delay, that motion is denied. However, a timetable is set. So a timetable is one way for a judge to kind of crack the whip on litigants who are stalling or taking too long, right? Where they can sort of say, well, discoveries have to finish by this point. I want to put down for trial at that point. If anyone has a motion, they have to bring it forward by this point in time, and then we want to have a trial by this particular year. So it's a way to crack the whip on litigants without going to this drastic step of dismissing the action completely. And a timetable will impose a set of deadlines which is more strict and more onerous than the timelines in the rules of civil procedure themselves. Okay, so September 23rd of 2003, our second, the defendants bring another Rule 24 motion to dismiss for delay. That is also fails, that's denied. But now the judge sets the matter down for trial, which means the trial is going to be actually scheduled. The examination is finally completed in 2004, but things go off the rails again, right? Because now we're trying to finally get the trial scheduled. But in July of 2004, the court office refused to permit the plaintiff to file the trial record to set the action down for trial on the ground that the nurses Jane Doe on the title of the action were not properly identified and named. Okay, so the plaintiff does not know the names of the nurses whom he's suing, right? He wants to sue whatever nurses were involved with his treatment. They haven't managed to figure out who those nurses were. They probably could have asked proper questions at examination for discovery to get the names of the nurses. The plaintiff was under the impression that you can just write the nurses Jane Doe. Maybe some other registrar would let that fly. This registrar said, no, you can't file this at all. So this is the kind of like procedural snafu that can easily chew up 6 to 8 months, right? Because that happens and then everyone's confused trying to figure out what to do next. Are we going to figure out the nurses' names? Are we going to try to get the registrar to accept this statement of claim as is? We don't know, right? So we're back to the drawing board. Another 8 to 9 months go by. We're into 2005 now. And in April, we have a settlement, a partial settlement with the nurses, right? So we don't have to worry about the nurses Jane Doe anymore. We've settled with them, or rather their insurer. However, we still have the doctors and the hospital who are being sued. So we go to July 22nd. The trial coordinator emails all counsel to set a trial date, with the earliest date for a 7-day trial being November 6th of 2006. Okay, so middle of July 2005, the quickest day we can start the trial is November of 2006. So this is an example of what we call systemic delay. That the system itself, the system is the source of the delay, as opposed to the plaintiff or the defendant or any other party. Okay, so the defendant refuses to set this down for trial, right? They say going to November is too long. We're going to bring another Rule 24 motion. So this is the defendant's third effort to use Rule 24 to dispose of this without a trial. And in August, so that motion is actually heard quite quickly, just the next month, that motion is heard and granted. So the motion judge says, plaintiff, your case is done. You've taken too long. And the motion judge's reasons are summarized at paragraphs 5 to 10. Okay, and then of course that motion, that order is appealed, which gives us this Court of Appeal judgment that you read. So that Court of Appeal judgment comes out in 2006, right? May 25th, 2006. So that's a total of 8 years and 9 months between the accident itself and this final appeal judgment on the Rule 24 motion. Okay, so thank God we're running out of cute PowerPoint transitions. We are finally at the end of this, right? So the defendants had won their third Rule 24 motion. The plaintiff's case had been dismissed for delay. And after giving the history of that I've just related to you, the judgment at paragraph 11 states the basic test that you need to know about this, right? So paragraph 11 tells us that mere delay is not enough, right? So no matter how many years it is, whether it's 8 years or 18 or 84 years, the mere passage of time is not enough on Rule 24. Instead, if you're the defendant, you have to show one of three things. So the first way you can win your Rule 24 motion is by showing that the plaintiff's delay was intentional and contumelious, which is rare, right? So this is like the plaintiff was, just trying to screw with you. Like they never really intended to bring this. It's a totally spurious motion, so that's almost never going to work, but it is there. The other two, we're talking about prejudice again, right? We talk about prejudice almost every class. Prejudice being unfair disadvantage to a litigant caused by the behavior of some other litigant in a civil action. And the first thing we can say about here is that the defendant can prove that the plaintiff's long delay has created a presumption of prejudice which was not rebutted. Okay, so what does that mean? Well, if enough time has gone by, then there's a presumption. The court is going to start from the assumption that the defendant has been prejudiced, and then the plaintiff has a chance to rebut that. And if they do not do so, then the defendant wins their Rule 24 motion. And the alternative, even if not enough period is passed to create that presumption, then the defendant can show actual prejudice caused by the plaintiff's delay. Okay, so I will repeat that. So both of these, back in two, are about prejudice. And if enough time has passed, then there's a presumption of prejudice which the plaintiff has to rebut. But even if not much time has passed, even if the amount of time which has passed is insufficient to give rise to that presumption, then the defendant can still show actual prejudice in order to win their Rule 24 motion. So what is prejudice? How does prejudice result from delay? Well, let me ask you. I mean, how would it for the doctors? If you're on for the doctors, right, the defendant doctors in this case, how does the passage of time make it more difficult for your clients to defend themselves, to rebut the plaintiff's assertion of medical malpractice and negligence? Here, your memory fades over time, and evidence can be lost. Right? Witnesses may be gone. Yeah, witnesses can die or leave the jurisdiction. With every year that goes by, that becomes more likely, for sure. So if you're Dr. McCall, right, you're the guy who operated on Armstrong's heel way back in 1997. Your best evidence is probably just to describe exactly what you did, right? The procedure you followed in operating on his heel, and then how that procedure was in conformity with generally accepted practices or whatever it is you're supposed to be doing when you're operating on someone's heel. But the problem is, for you, this is just one ankle surgery among hundreds that you will do over a 10-year period. And as time goes by, your recollection of that specific surgery 8 years ago becomes faded to the point of non-existence. Now, of course, everyone's memory fades, but that problem does not afflict the plaintiff in the same way. Armstrong has only had one surgery on his ankle. The events of that day are vivid in his mind because that's the day he was seriously injured. So the the passage of time affects everyone's memory, but it affects the defendant's memories, and it affects the defendant's ability to make their case more than it affects the plaintiff's ability to make his case. And that's why it's a possible source of prejudice to the defendants. Right? Armstrong, 8 or 9 years later, there's a good chance he can still get up there on the stand and tell his story in vivid and confident terms. Whereas if you're, if you're Dr. McCall, you're being honest, you're going to have to admit you can't remember much of anything from that surgery. Okay, so that's kind of where the prejudice comes from. So there's 3 grounds of appeal. The motion judge, of course, granted the motion to the defendant, and that's an appeal. So the first ground of appeal here is about what portion of the delay are we going to focus on, right? The plaintiff says the motion judge focused on the wrong period. The motion judge was focusing on the entire 8 years and 9 months that went by. That was wrong. The Court of Appeal at paragraph 18 in this judgment says it's not really about the entire 8-year period. It's actually more about the 17 months that passed since the second Rule 24 motion was brought and denied. Right? So the question here, what happened in the 17 months from the release of these reasons on the previous motion until the hearing before the motion judge that tipped the scales in favor of the defendants? Right? So it's kind of complicated, but the defendant tried 3 times to have the plaintiff's claims struck out for delay. First 2 times the court said no, and those decisions are not under appeal. So on the third motion, we have to presume that the second motion decision to refuse that dismissal for delay was correct, and only 17 months have passed since that. So what has happened since then, such that the plaintiff has now gone over the edge? So for that reason, you can think about just those 17 months. It's kind of like the plaintiff's delay is sort of like water in a cup, right? And the judge has to decide whether that cup is overflowing or not. So there was a certain amount of water in the cup already at the time of the second motion. We just have to decide whether the additional water that's gone into the cup, those 17 months, have pushed us over the top. Okay. So for that reason, we don't analyze the entire 8 years and 9 months. The other reason, of course, what's the other reason why we don't want to focus on the entire 9 years? Just because there's systemic delay. That's right. There's systemic delay, and there's also defendant's delay. Right. This is a motion which will punish only the plaintiff. And to the extent that the delay was caused by the system or by the defendant, then that's not relevant to the Rule 24 analysis. And systemic delay is big, right? So this guy's worth following if you're interested in civil litigation. He's a partner at Pallier Rowland. So this was his tweet, August 21st, 2019. First available date for civil pretrial in Brampton is March 2021. Not even a trial, right? Just to get into that civil pretrial hearing. Which it's a source of enormous frustration. And when you hear lawyers talking about why we want the feds appoint more judges, this is part of what they're getting at. Okay, so systemic delay is real. So what happened in those 17 months? What additional prejudice occurred during those 17 months? We do have on this third motion some new evidence from the defense about actual prejudice against them. On the defendant's first 2 Rule 24 motions, they didn't actually have any evidence of prejudice. Now they've got a little bit, but it's not enough for reasons we're going to see. And this rule, paragraphs 19 to 20, really explain this, right? So On this third motion, we have an affidavit sworn by Sarah Batner, a lawyer employed by the law firm that represents the physicians, the defendants. So what's wrong with this, right? So the evidence we brought forward is the lawyer, the doctors talked to their lawyer, and the doctors told their lawyer that their memories were fading, and they also said to their lawyer, well, we don't like having this hang over our heads for a lengthy period. And then the lawyer in the defendant's firm swore an affidavit saying that the doctors had told her this. So what's wrong with this? Sounds like evidence, right? Why is this evidence not persuasive to the court? What kind of affidavits do we like best when we're trying to figure out what's happening in the real world? Not the gold standard, right? Why not? Not first-hand personal knowledge. Should be personal knowledge. Yes. Now we're getting there, right? So this is evidence about how these doctors are being prejudiced by the delay. The best evidence would be to have them swear the affidavits personally. Instead, their lawyer did it. Now, there's reasons why the defendant would want to do this. It's cheaper, right? If you are on for the defendants, it's easier to have the lawyers already in your office swear this. Otherwise, you got to bring the doctors in, you got to take them away from their surgeries and so on. You've got to kind of get them up to speed on what's going on. They have to know what they're swearing to. It's more expensive to create good evidence from real people, but there's reasons why you do it, and this kind of shows why. Okay, so that's not great evidence. It's not useless, but it's not great. Many of the things that they are complaining about are not relevant in this case, right? So for example, costs. So if the plaintiff is delaying, then your legal fees as a defendant are going to go up because you have to pay. Even if not much happens in the case, you're going to have to pay a little bit month to month over the course of 9 years just to have the defense continue. But that's not relevant. Why isn't that relevant? If the defendant has to pay more money to their lawyers, why does that not help the defendant win a Rule 24 motion? Why wouldn't we strike out the plaintiff's claim just because the defendants? I mean, it seems unfair, right? Why does the defendant have to pay more than they otherwise would just because the plaintiff is delaying? There are other remedies for cost. Thank you, Jeremy. Right? So that's why we have cost awards. We know that one of the explicitly acknowledged purposes of cost awards is to compensate for extra legal fees occasioned by another party's delay. So we're not going to strike it out for that reason. Okay, moving on with Armstrong. So there's a question of whether the presumption of prejudice, this is the second round of appeal, whether the presumption of prejudice was applied. So we said here, this is about the second of these, right? The second way you can win. So the court is quite clear that the presumption of prejudice does arise. After 8 years, we're going to be presuming that there's prejudice to the defendants, and the plaintiff has to dispel that. However, the Court of Appeal finds the plaintiff actually has rebutted that presumption of prejudice. And this question turns on the extent to which it's a document case. Does anyone know what a document case is, as opposed to some other kind of case? Talk about this at paragraph 24 and 25. Basically, a document case is a case in which the evidence is documentary, right? A non-document case is one in which the evidence comes from people's recollections and their memories. So if it's a document case, delay is less of a problem. If we're trying to interpret some piece of paper or some electronic record, it's not going to fall apart in 9 years the same way someone's memory does. So this, the court finds, is to some extent a document case. We've actually got a lot of evidence which we've preserved, physical form X-rays and so on, doctor's notes, so that helps the plaintiff dispel or rebut the presumption of prejudice. Paragraph 26, they emphasize again that the defendants are to some extent to blame, right? They spent too much time, the defendants did, bringing these Rule 24 motions. They brought 3 of these. The court would have rather have seen the defendant focus on actually getting the case to trial. So that, again, helps the plaintiff rebut the presumption. The court definitely does not want defendants to use the time which they spend bringing Rule 24 motions against the plaintiff, right? We don't want the defendant to be able to say, well, 9 years have passed, therefore dismiss for delay, when in fact many of those 9 years passed because the defendant brought all these Rule 24 motions that the plaintiff had to spend time responding to. Okay, so disposition without trial is always appealing because it's like a quick, easy win, but the courts don't want it used strategically, and they don't want it being used at the expense of actually having substantive adjudication on the merits. Okay, so the third ground of appeal, the defendants say we have actual evidence of prejudice, but it's just this lousy affidavit from their lawyer, so that's not too impressive. It's hearsay, right? It's that's not very persuasive when it comes to showing that there's actual prejudice. And so in a conclusion, the defendants are going to lose, right? A finding of actual prejudice, this is the Court of Appeals conclusion, a finding of actual prejudice based on untested hearsay evidence is not enough to justify the draconian measure of depriving the appellant of an opportunity to attempt to prove his case on the merits. And were the action to be dismissed for delay, all of the very considerable costs that have been incurred would be thrown away. And I think that would be most unfortunate, right? So this is true, right? This is about the poor guy's ankle or his heel, right? Was he treated in a deficient, negligent way by these hospitals and this doctor, right? If we grant Rule 24, that means we'll never know. And all of the time and effort we spent trying to figure out this question will have been wasted. So Rule 24 is there. There is a discipline on excessive delay, but it's a high bar to cross for these reasons. And you better bring your A game and have good evidence of prejudice, even after 9 years, if you want to win one of these. Okay, so Rule 24, for these reasons, was seen to be not really doing the trick in terms of disciplining delay. On Thursday, we'll look at Rule 48.14, which is another technique we have that sort of fits in with Rule 24 to discipline delay, as well as the Limitations Act. Thanks very much, and I hope you have a terrific evening. I'll see you on Thursday.